Well, thank you so much for having us. I'm Carla Reyes. I'm serving as your moderator and and a panelist this morning. Again, we're coming to you to speak to you about digital asset remedies, namely the challenges and perhaps less challenges than you might expect in executing remedies against digital assets as part of dispute resolution. It's my very esteemed pleasure to introduce you to my esteemed co-panelist. Drew, you are up first, and I'll allow you each to introduce yourself before we dig into the materials.
Thank you so much, Carla. Good morning and good afternoon to everyone attending. I'm Andrew Hinkes. I'm a partner with K&L Gates, the co-chair of the Global Digital Asset, Cryptocurrencies, and Blockchains practice. Since 2018, I've been an adjunct both at the NYU Stern School and the NYU School of Law, where I've taught a class called Digital Assets, Blockchains, and the Future of Financial Services. And I have participated in law reform efforts, both domestically in the United States and internationally, surrounding the incorporation of digital assets in secured transactions and related technologies. It's a pleasure to be here. Thank you.
It's really great to have you. Hin, if you'd introduce yourself next.
Hi, I'm Hin Liu. I'm a lecturer of law at the University of Oxford. So I teach property law mainly, and also a newish module at Oxford called Law and Computer Science. So this is basically the intersection between the disciplines of law and computer science. Relatively self-explanatory, but we discuss things like anything from AI to cryptocurrencies to basically every single innovation that you can foreseeably think of. But this is more of a sort of, it's more of a law for computer scientists and then computer science for lawyers kind of course. But then I'm happy to be in the intersection between the two disciplines. So I'm also part of the advisory panel for the Law Commission's project on digital assets and private law. I've also been working on DAO legal issues relating to DAOs and things like legal personality. And I'm also a subgroup member of the Unidroit Digital Assets project.
Thanks so much. And so as I've said, I'm Carla Reyes. I'm an assistant professor of law at Southern Methodist University, Dedman School of Law in Dallas, Texas. I work with a variety of international, national, and state level efforts for creating principles and law reform around digital assets and private law. And I teach in the areas of secured transactions, business entities, blockchain law and policy, and AI. Similarly, that's where my research interests lie. I was a blockchain attorney before I was an academic, practicing at Perkins Coie in Seattle, Washington for 7 years before moving over to be a professor. So we're really excited, the three of us, to have the opportunity to speak with you this morning, and we will dig right in. Our preliminary this morning is to talk to you a little bit about methods of tracing digital assets, in part to dispel the myth that this is not possible. And we will also talk to you a bit about methods of freezing and attempting to recover digital assets. And lastly, a bit about automatic and algorithmic enforcement. So I'm going to turn the floor over to Drew, who will kick off our discussion around the tracing of digital assets.
Great. Thank you, Carla. As Carla alluded to, there's a persistent myth that transactions on digital assets are somehow secret or impossible to trace or track. It's born of a lack of familiarity with the forensic fingerprints that are left by crypto asset transactions and a lack of familiarity with the tools that are used in order to create those transactions. Most people at this point may have heard of these things called blockchain explorers, which actually provide a more robust data set regarding crypto asset transactions than those you would find in transactions of fiat, which we'll talk about in just a second. But at this point, there is a robust industry of forensic tools and service providers whose sole function is to provide both law enforcement support, well, whose dual functions probably are to provide law enforcement support as well as regulatory compliance tools and products for those who use these assets and engage in this industry. Now, digital assets are not anonymous in the sense that it is impossible to determine who's using a given asset or system, but they are pseudo-anonymous, which means that these systems do not natively operate in a way that gathers, collects, and stores and associates transactions with legal names. There's nothing on a blockchain or digital asset that would show Hindu sending an asset from an account that's associated with his name to an account associated with my name. Instead, you have systems that identify logical locations that can control and spend assets from that location to another location using a cryptographically derived credential called a crypto asset public key address. Crypto asset public key addresses are how these systems track and trace transactions from user to user. And so while you will never see a proper name on a blockchain, you will see the public key address. This allows for forensic service providers to use tools that aggregate and track data and compare that data against blockchain explorers to determine transacting parties and to determine who is engaged in transactions with who. This is what we call KYT, or know your transaction, versus perhaps the more familiar KYC, or know your customer, which is part of compliance programs around the world at this point. We need to think about a different paradigm where we're identifying contracting parties based on who they contract with or transact with often, as opposed to simply knowing who the party is that's using an asset. The focus of these technologies is not on the individual in as much as it is on the transaction, the historical attributions of those transactions, meaning with whom they have transacted previously, and the linkages that are created thereby. So you can't necessarily monitor a client or a person in the sense that a bank that is required to collect identity information can, but you can watch the movement of funds through an address in order to correlate with which other addresses that address will transact. Now, because these systems create novel data, there are new novel tools that have emerged. But as I alluded to earlier, the bedrock of all this is a feature of most public network blockchains called blockchain explorers. These are native functionalities that allow for the creation of websites that display all transaction activity occurring on that blockchain by its users, basically in real time. What it shows you is transactions of value from users identified by their public key addresses to other users. And so unlike any other system, cash, for instance, there's no record created usually. And in electronic versions of cash, that data is usually siloed within financial institutions who have typically legal obligations both to protect that information, to make it non-public, but also to collect that information and report it only to private entities or governments. Here, blockchain explorers show all of this information publicly to anyone who has a web browser and knows how to read it. However, this is only part of the story in the sense that you only see value flowing in one direction. We know that for legal transactions, there is usually consideration flowing in the opposite direction. Hin might send me a Bitcoin, and you can figure out what address Hin controls and what address I control. You can find that transaction on the blockchain, but you won't know why. You won't be able to tell that I sold my Tesla to Hin, for instance, in exchange for that Bitcoin. You're welcome, Hin. So you can't tell simply by looking at a blockchain what value is flowing in the opposite direction of a given transaction. And so forensic service providers employ a number of novel tools in order to determine who might be the user of a given address. They will look at pattern recognition. They'll look to see if there are repeated transactions with other wallets. They'll look to see whether a given address is reused at certain times and with certain parties, and they will look to see whether certain addresses appear to be used together frequently. All these different types of typologies of use can be indicative of correlation between addresses, either indicating that the address might serve a function. It might be a wallet address used by an exchange, for instance, or that a certain number of addresses being used together may be within the same control of the same entity or person. Service providers, of course, need to start somewhere, and so generally they do one of two things. They'll buy data sets from regulated intermediaries or from legally addressable intermediaries that collect data or use the data themselves, like crypto ATM companies or exchanges. Or they can employ analysts that will be given crypto assets and be told to go out and make transactions and keep a log of what addresses are used by which entities or software services or service providers. Some providers use honeypots, which are decoy targets that are intended to lure would-be attackers and collect information about them in order to identify hostile actors. And in some cases, they'll also be able to correlate IP addresses with digital asset transactions in order to try to unmask those persons using additional data that doesn't natively exist on a blockchain. And this is sort of illustrative of the bigger tension here between anonymity and disclosure, the ability to determine who is a person online versus the desire both from the sort of early adopters and those who believe in some privacy rights to have pseudo-anonymous systems and to not necessarily have them be unmasked. This push and pull can be seen can be seen very well in the issue of how tumblers and mixers are regarded by law enforcement and by regulators. Tumblers and mixers are technologies, some of which are native to the protocols, others of which are built secondarily, which allow for users to break the relationship between sender and recipient. So that if you are looking at a blockchain explorer, you can't necessarily tell who is the sender and who is the recipient. These are obviously important and powerful privacy tools, but they're also tools that can be used by money launderers and criminals to try to obfuscate the source of funds and to try to clean funds going forward. We've seen the United States Office of Financial Asset Controls recently sanction and list a number of mixers in an effort to stop certain money laundering rings and drug trafficking rings that have unfortunately tried to use this technology. And so this is an area of interest. Another area that was typically used in order to try to preserve privacy or potentially to launder funds is chain hopping, which is using cross-chain bridges in order to transact from one blockchain system to another. It turns out that blockchains live in their own network, and it is difficult to get the assets created and maintained on those blockchains out of that network. Since about 2019, folks have been working on technologies that would allow assets to essentially the value from one system to flow into another. And the forensic service providers at this point have been able to put together tools that are able to trace transactions across chains. All of the data that is created, all of the tracing that is conducted is probabilistic in the sense that anyone can use a wallet address, and it is not clear at any time which person is actually using it. The control of a wallet address is conferred by the knowledge of a private key. It's a piece of information. If I tell Carla my private key, now it's possible that Carla is using that address in addition to me. So there are certain assumptions that are inherent in the analysis, but to date, this analysis has been relied upon extensively by law enforcement and in private litigation without much argument. Next slide, please. So now that we understand that we can follow the bouncing ball and trace these transactions, can we actually get them back if there's a good legal basis to do so? Obviously, courts have the power to compel legally addressable entities like persons and recognized entities to do things. They can enter injunctions, they can enter mandates, and so forth. So courts are definitely not toothless here. However, they do need to be able to identify the party that might have control of a certain asset and use power against them. We've seen Moreva injunctions, we've seen preliminary injunctions, we've seen freeze orders, we've seen requests for information sent to legally addressable entities related to the possession and control and ultimately the turnover of these assets. But you run into a problem when you can't identify exactly who has an asset. And you run into a problem when an asset might be negotiated to the control of a smart contract. A smart contract is a set of code that tells a system how to control a digital asset. That smart contract may not be controlled by any legal entity. There may not be a person out there who can stop it or change it. And so the result is if you can't find a person, you may not be able to use court power against them. And if a digital asset is controlled by a smart contract, even a court who wants to do something, who has the power to coerce a legal person, may not be able to coerce a smart contract to rewrite its code or to not execute or to execute at a given time in order to transact that asset to a third party. The result may be that courts and litigants and parties seeking to use court power may be limited to ex ante and ex post remedies only. We have seen the issue of whether certain types of relief are available for certain types of digital assets. The courts are still sort of wrestling with the understanding of what these assets are and are not and what they mean. Many courts have looked at whether crypto assets are sufficiently unique so as to give rise to irreparable harm. There's likely a continuum of assets where some may be sufficiently unique, like NFTs, where you can make the argument that they are in fact unique and that you can't simply substitute in a different one, versus digital assets like perhaps Ethereum or Bitcoin, which are more fungible and where you can substitute one for another. Courts are still trying to determine when there's a loss related to crypto assets, whether the awards should be given denominated in fiat or in crypto. Most orders basically say, go get the crypto, and if you can't, come back to me and we'll try to fix the amount of damages expressed in fiat. But if you pay attention to this industry, you know that pricing and valuation is highly dynamic. There can be vast swings in value on a daily basis, and so it's an area that we'll probably see continued evolution on. And of course, since we control these assets with private keys, which are information, sometimes people forget the information. There are legion stories of people who forget private keys and lose access to massive amounts of money. It is both part of the power and part of the vulnerability of these systems. Litigants may seek to recover crypto assets and find that their adverse party claims that they've lost the private key and so they can't comply. This implicates the power of courts to coerce people using contempt, for instance, to comply with orders to do things like turn over assets. Contempt orders are, generally speaking, things that courts can do to legally addressable persons to make it unattractive to hold out and not comply. But if you've actually lost a private key, it may be impossible to comply. On the other hand, it's very difficult to determine whether someone actually has lost a private key or is simply saying that they lost a private key so that they can be excused from compliance. In the United States, courts may enforce their own orders. In continental Europe, usually it's incumbent upon parties to move for this relief and to seek the court's approval of these sorts of sanctions. And they can be particularly nasty. They can include incarceration in the United States beyond 15 years in one instance. So these contempt orders may not actually solve the problem. They may simply make the injury for the person who's lost the assets even more unpleasant. There could be some technology and legislative opportunities there, but so far we haven't seen it come into play yet. And the last comment here is that regulation that's sweeping the globe has required legally addressable parties who interact with these systems to collect data, to collect new data, and in certain cases require technology providers to create new systems to carry data that's not natively required to be created and carried by these systems. I'm alluding to vast pools here. Overall, this increases the amount of data that's created and collected and results in more data being available for these forensic service providers. So the trend is for there to be more data available, better data, and ultimately better tracing opportunities out there. Next slide, please.
Actually, Drew, I'm going to interrupt with a question real quick. Earlier, you mentioned that you said NFTs might be unique enough to sufficiently unique enough to cause irreparable harm, but while other crypto might not. And I was wondering, for the less technically inclined who might be listening to us, if you could elaborate a little bit on why that is true and what might the factors be on this continuum that you described of unique to not as much.
Sure, and I've actually argued this in an injunction to a court. So this is sort of a fun issue. One of the factors that courts look at when determining whether to enter an injunction is whether there is something that is sufficiently unique so that if the injunction does not freeze the asset, for instance, that it might be lost, and that there isn't an equivalent good that could be substituted for it so that the party ultimately can be made whole once there's a determination on the merits, rather on a sort of preliminary or proprietary set of relief. And so we see these sorts of orders entered all the time for things like art and so forth, where it's unique. There's maybe only one copy of Guernica, for instance. NFTs are what are called non-fungible tokens. They're unique assets that, unlike other similar digital assets, can be traced from their creation through every transaction to the current holder. They are typically associated through a license or some other relationship with art or with some sort of audio-visual asset. And they become very popular as a way for creators to interact directly with fans or audiences, and they've become very popular. An NFT can be viewed as essentially a claim of provenance or digital authenticity as to a certain piece of media. And so there may only be one NFT that confers this high claim, this high dignity claim to this asset. And so issuing a second NFT, for instance, may actually dilute the value of both. And so those assets might be sufficiently unique in order to give rise to irreparable harm if they are lost. Other assets like Bitcoin or Ethereum are more fungible in the sense that whatever you can do with one Ethereum, you can probably do with a second Ethereum. There's nothing unique about any given Ethereum in most cases that would lead someone to suffer some sort of injury if instead of the Ethereum that they lost, for instance, they were given a different Ethereum instead.
Perfect, thank you.
So maybe we can move on to the next slide.
Can you see that?
So these images are excerpts taken from enforcement actions. One back, please, Carla. Thank you. These excerpts are images taken from enforcement actions brought by the Department of Justice against purported criminals who were using crypto asset systems in order to launder the proceeds of illegal activity. On the left is something that is an image that describes something called a peel chain. This is a typology where a party receives a large amount of data, of digital assets, and sends a small increments of that digital asset to a number of other addresses, which then sort of peel off pieces of it and send to others, ultimately to be reconstituted at an address several transactions later. The chart on the right shows a series of movements among different participants in a scheme of Bitcoin related to another type of criminal activity. The specifics of the transactions at issue are not relevant. The point of this slide is to show you that at this point, 13 years into the existence of crypto assets, law enforcement uses tools to trace routinely, has become very sophisticated, and the forensic results are generally accepted by courts in the United States without challenge, and so far have been successful.
Great, thanks so much. So that puts me up, and I'm going to spend a few moments now talking to you about a specific example that illustrates many of the things that Drew just described. In particular, we're going to look at these issues in the context of the stolen funds from the LCX exchange. So by way of background, hackers, or a hacker, singular or multiple, it's not entirely clear for the reasons Drew described, stole nearly $8 million worth of cryptocurrency from the LCX exchange's hot wallets in January of 2022. They attempted to use the Tornado Cash crypto mixer to launder the stolen digital assets, and that perhaps has more meaning now than it did when this news about this case and the enforcement actions or recovery activity first broke in June. as you may or may not be aware, Tornado Cash is now on the specially designated persons list for sanctions from the United States. So part of that, of course, has to do with that theory that you can't figure out what happens to the crypto after it goes through a mixer. But as Drew's described, that it is entirely possible in many instances to continue to trace digital assets through mixers, even though mixers do provide additional privacy to transactions. As a result, the LCX hacks team was able to algorithmically trace and identify wallets that control the stolen digital assets, the assets that had been stolen from them, even those that went through the Tornado Cash crypto mixer, which I think is noteworthy for a variety of reasons, particularly now in light of the relation to the sanction list. It's worth noting as well, I think that to do this tracing, LCX used a German-based company called Elliptic. It's one of the analytics companies or Chainalytics companies that Drew was describing in his presentation. And notably, Elliptic is not a US-based entity. I think it's worth noting that in particular, because when I talk about this topic with folks from jurisdictions other than the United States, some of the response is often, well, we wouldn't be able to do that in our jurisdiction because we have better privacy laws than you. And that notwithstanding, to the point that points that Drew made earlier, much of the data that is used to conduct the algorithmic tracing, the Chainalytics, is available publicly and openly as part of the transactions of the ledger, and you are able to conduct this type of analysis in most jurisdictions at this point. All right, so as of June 7th, 2022, 60% of the funds that had been stolen from LCX had in fact been either through various court orders and in particular in collaboration with law enforcement around the world, including from Liechtenstein, Ireland, Spain, and in the United States. So again, the point here is indeed you can identify digital assets that were stolen or redirected or misdirected or mixed. You can trace them to the new wallets where they land, and once you figure out where they are, in many instances, in this instance in particular, at least as of a couple of months ago, and I haven't heard any updates since then, they were able to recover 60% of, or at least recover or freeze 60% of the funds that had been stolen from them. So it is, to the point, in fact, possible to recover digital assets despite the myth that it is not. Okay, so how did they accomplish this? Well, sort of through three tacks. First, they obtained a court order that did three things, and we'll talk about the three things in turn. But in particular, they ordered the defendants not to use the stolen funds any further, right? Just stop. You're not allowed to use the funds anymore. Second, they were able to freeze funds through a centralized entity. So in particular, some of the stolen funds were traced to a Coinbase account, and Coinbase Europe in particular, based in Ireland. And this is worth exploring a little bit further because Coinbase, of course, is an intermediary, and generally speaking, a fully regulated intermediary. That means that anyone holding an account at Coinbase has gone through the KYC identification procedures at Coinbase and is generally fully verified. Thus, if you sent stolen funds, if you are, stealing funds or trying to obfuscate them or hide them from collection later, and you send those funds to a intermediary that fully verifies accounts, what you have done is take maybe something that makes you difficult to identify and put it into an account that's not difficult to identify at all, and indeed allows you to follow fairly traditional mechanisms of serving court orders and freezing assets and recovering assets through third parties. So in this instance, the LCX exchange legal team worked with the police and with prosecutors in both Ireland and Liechtenstein, and the court was ordered able to order Coinbase to freeze the funds, and Coinbase did so. And now, of course, post freezing, they're working with further legal process in order to actually recover those funds from the accounts. The second tack that was taken in order to trace and recover the stolen digital assets was to issue an order to a centralized issuer of digital assets to freeze the fund. So this is slightly different, and it's important to note the differences between these first two activities. One was to order a intermediary to freeze funds, and those funds may have been in digital assets that continued to be decentralized, not have a centralized issuer. They just happened to be held at an intermediary who had control over the wallets that they were held in, so they could freeze the assets this way. This second tact was enabled because the hackers, and I laugh because I find it fairly funny. You're sophisticated enough to steal $8 million worth of digital assets, and then you transfer intermediary and you transfer it into centrally issued digital assets. But okay, I guess no one said thieves were terribly smart. But in any event, some of the hackers transferred some of their stolen digital assets, or the assets they had stolen, into USDC. And if you're not familiar, USDC is a centralized digital currency. It's a stable coin. It is issued by Circle Financial Services, and Center Consortium operates the technology generally on which it is transacted. So a New York court was able to order Center Consortium to essentially blacklist the wallets under their network denial policy and ultimately freeze $1,275,000-ish worth of USDC, just freeze it on chain. So now you have digital assets held by a custodian that the hackers are no longer able to access, and you have digital assets literally frozen on chain by the entity who controls the chain, essentially, as two ways to freeze and then hopefully eventually, after additional legal process, recover those assets. But do indeed note the technical difference, right? In one case, the Coinbase case, it is that Coinbase holds the assets and is able to control them, and so you can have Coinbase just be preempted from continuing to transfer those funds, right? Coinbase is required to just continue to hold them. In the other case, the technical tact is that you go to the entity that controls the ledger, the blockchain protocol itself, and ask them to take technical measures to prevent the holders of wallets, so still the hackers, from being able to further transfer the assets. It's a slightly different technical way to achieve the same thing, namely freezing and holding in place assets until further legal process can determine indeed that those assets belong back to, in this case, LCX. Okay, the third part is really my favorite part, not because the hackers were funny or not terribly smart, but because the lawyers were particularly creative. So the third thing that was done in this case is that a New York court ordered or issued a temporary restraining order and ordered that it be allowed, essentially, that LCX exchanges lawyers, in this case the law firm Holland and Knight, were able to serve that order on the defendants who, for the reasons Drew described earlier, whose actual identity was still unknown, right? They just had wallet addresses, obviously, since they were able to trace the digital assets through them. All they had was wallet addresses, so the court allowed Holland and Knight to serve the order and the documents that enabled the Holland to obtain the order via NFT, that very type of unique digital asset that Drew explained presentation. In particular, the NFT was embedded with a link that if you clicked on it, and we'll talk about that in a minute, but if you clicked on it, it would take you to this website linked here at the bottom of the slides, which would include all of the documents that were used in support of obtaining the TRO and the order itself, in order to essentially provide complete civil procedure rights to the John Doe defendants. So you're like, that's great. You're saying they served an NFT, they served a subpoena via NFT, and they served a TRO via NFT. Like, what does that mean? Like, great. Like, yes, you explained to me what an NFT is. But like, what would it look like if I was the defendant? What am I actually getting? I'm still having trouble visualizing this, right? So here is, if you had a Ethereum account, and note, this is my just like mock-up account for illustration purposes only. You'll see it only has like $2 worth of Ether in it. The reason being, you don't normally like want to flash your stuff all over the internet, right? So this is generally security best practices, is to create a dummy account to show you. So anyway, here's my dummy account. If you were to click on you see here, and if in case you don't have your own wallet, if you on this side you see tokens, right? So for here it just says ETH, but you might have other tokens listed, your other balances. But if you were to click on this other part right here where it says NFTs, you would see any NFTs that you own. And in this instance, I don't have any because it's my dummy wallet. But if you were to be the defendant and you received or were served the TRO and a subpoena via NFT, what would happen is they airdrop it to you, meaning they just stick it in your wallet, and you would basically open this up on your phone, on your computer, and you'd look to your NFTs and you'd be like, oh, look, there's a brand new one in there. That's interesting. And it would look like this. In particular, this is what the Holland and Knight service NFT looked like, right? And if you were curious, but perhaps not terribly smart, maybe that accurately describes our hackers, you might in fact click on the link, which would take you to the website with all the documentation. Notably, the court required Holland and Knight to embed in the link a way to tell whether the defendant had in fact clicked on it or not, as part of the order. So I make a joke about whether you may or may not click on the link, but Drew and Hin, if it was you, would you click on the link that just magically showed up in your wallet one day?
I'll start. Because I'm a lawyer, I would not do this, but most people who are looking at their wallets and see something new would definitely be curious. They would want to try to understand how it got there or what it's about. If it said something like service, as a lawyer, we would all look at that with something of a jaundiced eye. But to a non-lawyer, I think that the curiosity may get the better of them.
Yeah, I totally agree with that, because I think most of my friends who are in their 20s, for example, would definitely click on it because they'd probably think it's a new airdrop or some other NFT that's called service, and it's not service in the legal sense, but someone's performing a service for you, and you might want to know what that service is. So I think 90% of my friends would click on that.
Well, so then maybe it works. Are there any security reasons why you wouldn't want to click on random links in your wallet?
Yes. There are many different intrusion vectors and attack vectors that show up with crypto assets. There are lots of man-in-the-middle attacks, spoof attacks, and other hostile code that can be used to, in some cases, take assets out of wallets. So although the curiosity may get the better of someone if they've been attacked and lost assets before, they may look at that and say, no way, I want nothing to do with that, and just leave it alone.
Precisely. So, okay. So thanks, guys. The last thing I'll mention here is that if you wanted to check out the Block Explorer that Drew had described in his presentation, particularly for this service NFT. This is the record that you would find, just by way of an example, in case you've never visited Block Explorer before. But this is the record you would find and the types of information that you could drill down to further if you visited the record. And with that, I will turn the floor over to Hin, who will further describe additional cases in this regard and take us onto our automatic and algorithmic enforcement discussion.
Cool, thanks, Carla. So I think the first case I'll be discussing is the English case of Osborne. So this involves NFTs and asset recovery in respect of digital assets. And I think this is interesting because the case discusses some conflict of laws issues and also discusses the various orders that can be granted in respect of digital assets that are misappropriated. So in essence, the facts involved a claimant who held 2 digital art NFTs in her wallet, and there was a phishing attack that was perpetrated on the claimant. So this eventually resulted in the NFTs being transferred to 2 wallets on the OpenSea platform in New York, and so the claimant sought various orders in an attempt to recover the NFTs. So the court did grant various orders in an attempt to preserve and recover the assets, and there were injunctions granted against, firstly, persons unknown, so presumably fraudsters of unknown location, and also against the platform to freeze the NFTs in the wallets on the platform. And so the court accepted that NFTs were to be treated as property as a matter of English law. And also interestingly, that the loss of the NFTs was held to be non-compensable by damages, meaning that damages weren't an adequate remedy because of the unique value of an NFT, which owes to its non-fungible nature to it. And this opened up various remedial avenues to recover the assets themselves. And there was also a good arguable case for a constructive trust over the NFTs as representing the proceeds of fraud. And also the court talks about the location of the NFT and said that it was difficult to locate the NFT as such because they don't have a physical location. So the court then described the NFTs as a stream of electrons where the servers relevant to the account are maintained. And I think this raises a broader theme, this paradox of trying to assign a physical location to an asset that's fundamentally ideational. And this will necessarily involve some incongruence or dissonance. But there's an emerging trend in English cases to treat crypto assets as being located at the place where the owner of them is domiciled. So I find that quite interesting, and I'm going to discuss this a bit later. But just in terms of service out of the jurisdiction, the court talked about this as well because the defendants weren't located in England. And service out in English law depends on certain gateways. So this is, in essence, certain factors that connect the claim to England as a jurisdiction. And these gateways include causes of action like torts and breach of contract. And in this case, the constructive trust claim activated one of the gateways, and so service out was granted. And the assets were to be treated as if they were in England because the claimant was domiciled in England. And in terms of the concrete orders to assist the tracing of the assets, the proprietary rights in an NFT was also a gateway for a banker's trust order for essentially the disclosure of documents, as opposed to the Norwich Pharmacal order for obtaining information from a third party. And the courts take a very different approach to the latter because they generally refuse to grant permission to serve out of the jurisdiction in respect of a Norwich Pharmacal order. And an order was made against the platform to reveal the name, the address, the email, etc. of wallet holders and ultimate beneficial owners. I think this point's interesting because it raises that broader question of needing a focal point, so an entity or an individual to anchor the order. So what do I mean by this? I mean that this focal point, entity or individual, needs to have the factual ability to give the relevant information to the court. And I'll expand on this later, but the point is that since certain blockchains are designed in a way that no one has this ability, for example, in a very decentralized blockchain, this causes problems in terms of enforcement. So let's switch gears to a DeFi project, MakerDAO. And this is essentially arguably the first major DeFi project, and it's a borrowing protocol. And it's a project that consists of smart contracts built on the Ethereum blockchain. and it consists of two tokens. So you have the DAI stablecoin and the MKR governance token. And what happens is that people who want to loan would lock up Ether, so they send that to an address, and then in return they get the DAI stablecoin, which is minted for them, and no KYC is needed in this process. And the DAI token has a soft peg to the US dollar, and holders can withdraw up to 2/3 of the value locked up in Ether, so they can have ready access to their funds and do more with it, with a collateralization ratio of essentially 150%. And you can lock up more ETH than you can withdraw and DAI because of ETH's fluctuating value, and that's why they over collateralize it by 50%. But MakerDAO has survived many fluctuations in ETH's value, so it's survived a 91% drop in ETH's value, so it's a relatively robust protocol. But then what if the collateralization ratio drops below 150%? Well, what happens is that the ETH holdings get liquidated with a very hefty 13% penalty fee plus interest, and which brings me to the interest part in the DAI loans. So this is called the stability fee, and what's interesting is that this fee is determined by holders of the governance token MKR, so that this is the second token that I mentioned, and they vote on the fee. And there is an incentive for MKR holders to keep DAI pegged at 1 USD. For example, let's say that there's an oversupply of DAI. The price would drop below 1 USD, and then MKR holders would vote to increase the stability fee. And this incentivized DAI holders to pay back their debt, or at least part of their debt in DAI and interest in MKR. And so if this happens, the DAI is burnt, which takes it out of circulation. And this decreases the supply of DAI, which then drives the price back to 1 USD. Now, overall, so what is the breakthrough of DAI? So I think there are three elements. First, at that time at least, you could this breakthrough is very significant because you could very quickly get a loan backed by one currency that's collateralized by another currency, and this is of unthinkable speed for a traditional bank. And secondly, that the interest rate governance is democratized because it's distributed amongst holders of MKR. And thirdly, and most importantly, all these things are done by algorithms, which brings me to the question of judicial remedies and enforcement. So I think it's important to note that enforcement of collateral and liquidation in DAI is automatic as opposed to manual, in contrast with traditional systems of clearing and settlement, where you have to have a centralized entity, you have to have various entities in the middle, like clearinghouses. And in the digital asset context, this is a faster and more efficient way to settle transactions. But I think that's only one side of the coin. And there are new problems that arise when we consider interim remedies in the algorithmic digital asset context. And I think the key question here is, well, how do we reconcile these new features in relation to algorithmically locked assets and liquidations with the traditional system of interim remedies designed for physical goods and bank debts? So a general example would be if we want to freeze a wallet that contains an algorithmic stablecoin. And what are the differences between physical asset and digital asset enforcement? Now, certain assumptions that apply to enforcement of a physical asset often break down in the digital asset context. For example, let's say physical assets exist in a defined location that people can access. It exists somewhere in the world. But then for digital assets that are algorithmically locked, you can't access them. You can't brute force your way into a digital asset like you can brute force your way into a physical space. And I think the key issue to consider when designing enforcement laws for digital assets is to see which parts of the enforcement regime for physical assets can and can't be replicated. And so let's say the Norwich Pharmacal Order in English law. This is an order against a third party to disclose information to a claimant. And in civil fraud, this NPO is usually sought against a bank, where the bank will give information about the account holder, which will allow the claimant to identify the fraudster and then ascertain whether there are any funds in the account, so whether they've been drained, etc. And for freezing orders, most wealth is being held at banks, so in relative terms, it's quite easy to freeze the majority of a person's net worth. You just tell the bank to freeze an account. And if we compare that to digital assets, we may be able to have a freezing order or NPO or its equivalent against the issuer of the token, But we can't do this for blockchain tokens where the algorithm or protocol is designed in a way that the assets can't be frozen unilaterally by anyone who has the power to do so, because, or as in most cases, the issuer doesn't have any personal information about the wallet holder because there aren't any KYC checks. And many smart contracts and programs are deliberately designed to have no issuer. And I think insofar as the design of the blockchain protocol, an algorithm means that many assets can't be frozen or recovered, and there's limited information about each account holder, subject to what Drew and Carla just mentioned. Practical methods of enforcement seem to run out. And so solving this problem, I think, would really require ex-ante regulation, so we're not really put in this position, which would in turn require international cooperation. And I think this issue is much more difficult in the digital asset context as opposed to the non-digital asset context, because either a physical asset exists somewhere in space, or in the case of a bank debt, we can locate the bank and order it to disclose information or freeze the assets. But the very nature of how certain digital assets are designed is such that unique issues of enforcement arise very specifically in this context. And I think I want to zoom out now and examine more broadly the interplay between market players and users of digital asset services and, on the other hand, regulatory law enforcement. And this is basically an extension of what Drew mentioned in his presentation. And I think the interplay is very interesting because there will always be a degree of cat and mouse or back and forth, because there's always demand for anonymity and there's always demand for transparency. So on the transparency side, regulatory and law enforcement entities always have a desire to know where the assets are, who owns what, the flow of assets, and basically how to freeze and recover them. On the other hand, you have anonymity, and this gets a bit of a bad reputation because the desire for anonymity could be associated with illicit activities like drug dealing, money laundering, etc. But I think it could also be basically anyone who wishes to keep their transactions private for whatever reason. They don't want their entire transactional history to be disclosed to the public. So this could literally just be an employee paid in crypto who doesn't want to let his boss know how he's spending his money, so he might use a mixer like Tornado Cash. And according to one source, almost 80% of the transactions processed by Tornado Cash are actually legal transactions. We could also have someone who makes a donation to a political cause in relation to wars or charities, and they don't want other people to know that they've done this. Or it could just be that you've paid for a service in ETH and you don't want the person offering you the service to see everything that you've ever done on chain. And crackdown and bans on services that provide anonymity on the blockchain context, like Tornado Cash, I would suggest don't remove the fundamental human demand for anonymity. It's just solving the problem, solving the symptom of the problem as opposed to the root. And I think this is inevitable because to be able to solve the root of the problem, we would have to be able to suppress human nature itself, which, as we know, is not exactly the easiest thing in the world to do. And the desire for privacy is, to varying extent, fundamentally baked into us as humans. And this cat and mouse dynamic plays out in the form of regulators and law enforcement entities banning an activity, and then market players coming up with a new activity that meets people's needs, even if this includes skirting around the rules, bending them, flouting them outright with the hope that they get away with it, etc. And I think this is inevitable because the ban, as I said, doesn't remove the fundamental human need for privacy and security. And when there are unmet needs, it's just the law of the markets. Market players come in with products and services that meet them. And inevitably, these products and services get more and more sophisticated as they're going to be designed in a way which makes it hard for regulators and law enforcers to detect the flow of transactions and also the people behind them, which, ironically, from a regulation and enforcement perspective, is potentially counterproductive, because the ban actually makes it harder to reach transactional transparency in the long run. And I think this kind of interplay also happens in the finance space and the tech space generally, like for ICO and the securities debates, like people using various structures to skirt around the rules on securities offerings, and also just using the internet in the 2000s to launder money, and also offshore tax havens. So I think that regulation, whether ex post, ex ante, to achieve the goal of perfect enforcement may be thought of as more of an aspiration as opposed to something that's a realistic target, and we can only do our best to try and prevent these malicious actors from being able to take advantage of the system. And with this in mind, I want to discuss the bigger picture arising from one of the issues in the Osborne case, which is the conflict of laws rules in the digital asset space. And as I said, the core conundrum is basically trying to assign a physical location to an ideational asset. And because, well, digital assets don't have a physical location, it's necessarily going to be a proxy if we rely on a physical metaphor. They don't actually consist of molecules, even though molecular and physical structures, including electrons, are necessary to create the digital asset. So they're necessary for the digital asset to exist, but the digital asset itself doesn't consist of anything physical. So if we talk about things like the location of a digital asset, how we determine that, how do we determine that? There are various possibilities we can think of: the server, the nodes, the issuer, the holder, all those locations. And the risk is that this would undermine certainty. And there's a further layer of uncertainty because there's uncertainty within each possibility as well. For example, the location of the nodes. Which nodes? Are we talking about the majority of nodes? Alternatively, we're talking about where the nodes tend to be concentrated. We don't necessarily want people to be litigating over such technicalities. And the issue of technicality may also play out in terms of determining the location of, say, a holder of a digital asset, which gives rise to very technical arguments about whether a custodian holds a digital asset, whether it has access to it without holding it, etc., which is not exactly the best use of court time, I would suggest. And so I think the solution might not be to find the perfect word that fits the scenarios, but to find a word that's good enough to capture the majority of cases that are intended to fall within the rule. And ultimately, in the conflict of laws space, it might be more important to make sure that we have a level of certainty about how the rules apply and that we match people's reasonable expectations. So in the conflict of laws, there are essentially two reasonable expectations. First, where can I reasonably expect to have to go to defend my claim? So this is the jurisdiction issue. And secondly, which country's laws am I expected to be bound by? So this is the applicable law issue. So if my transaction involved Hong Kong and Singaporean parties operating under Singapore law, I would be expected to go to defend my claim in the US, let's say. It will be subject to US law. And the reasonable expectations point is critical because the rules can potentially apply to anyone in the world, as opposed to just anyone within the jurisdiction. So the rule needs to accommodate a wider range of people, a much wider range of people. And I think this reasonable expectations and certainty approach is very different from the technical precision approach. And I think the emphasis on technical precision comes at a huge cost because we have confusion, we have uncertainty, we have insufficient regard potentially to the purpose of the rules, and also insufficient flexibility in adapting to technological advancements and therefore people's reasonable expectations. So we might be able to use concepts like issuer and location as metaphors, and we can't lose sight of the fact that they're essentially terms of art to a certain extent. And I think we just need to be clear about the meaning of these terms and how, in particular, the meaning adopted for the purpose of the conflict of laws rule is different from the technical meaning. And I think this is obviously a very delicate balance. If we go to technical, you have the disadvantages that we talk about. If we go to functional and make the formulation or the word significantly deviate from its meaning, you end up misleading people as to the content of the rule. So in essence, we're trying to find the sweet spot. I wonder what you think about this, Drew and Carla, because this is a conundrum that I've been thinking about for a long time, and I don't quite know how to resolve it.
I think that it is certainly a conundrum to be thinking about for a long time, that we will be thinking about for a long time. And it's a good place to end and leave to future panelists to figure out for us, because we are, in fact, out of time. So thank you very much for your comments in. Thank you, Drew, for participating in the panel. And thank you to those of you watching.